The rule with double jeopardy says that after trial happens, the prosecutor really doesn't have a remedy, right? You can't come back and charge someone twice for the same crime.
It's really hard to convict someone just based off of their demeanor.
The real issue in the case is about how long these blood tests are taking to come back.
It's taken longer and longer the more I practice.
The Supreme Court is saying, hey, unless you set your DUI case for trial, there's no way to hold the prosecution's feet to the fire. So the first one I got here is People versus Walthour. That's a Colorado Supreme Court case issued on October 23rd, and it is a direct petition to the Colorado Supreme Court from the district attorney, which is kind of interesting. We don't see that a whole lot. Normally, the rule with double jeopardy says that after trial happens, the prosecutor really doesn't have a remedy, right? You can't come back and charge someone twice for the same crime. So if the prosecutor is going to appeal, they either do an interlocutory appeal. But in this case, that wasn't relevant because that only happens if a judge suppresses evidence, like evidence of a search. But in this case, the Supreme Court exercised its original jurisdiction to review a discovery order from a judge in a case, essentially because there's no other remedy available other than them taking on that direct review. So, the rundown of this case, this is a DUI.
Yeah.
Right? And it's looks like a single car accident that happens with, I think it's Miss Walthour. And police respond to this accident. They develop probable cause during their investigation to believe that she was driving while intoxicated. They invoke Colorado's express consent law, right? And that means that at that point, she has to take a chemical test of either her blood or breath to determine if she's driving under the influence. And she elects blood, so she has the test done of her blood, but the real issue in the case is about how long these blood tests are taking to come back. And what's been your experience with getting blood test results back?
It's taken longer and longer the more I practice. So currently it's taking about, I think 120 days for blood to come back.
And they had something similar in the opinion where the judge says, I think the DA actually in the case said that the time was averaging between 90 and 120 days for the blood test results from the Colorado Bureau of Investigations to come back. So that's anywhere between 3 and 4 months after a person is charged with a crime to get what's really the essential evidence in the case back is the blood test. So my reading of this is frankly, I think the judge got irritated with these chronic delays in getting that evidence back and really tried to take the prosecutor to it. At one point during the trial court proceedings, the prosecution says, hey, we're going to have these blood test results back. I think it was mid-February. The lady had been charged in November, and the judge goes, all right, well, I'm going to hold you to it. That's going to be the deadline for you to provide those blood test results. She's going through trying to get a public defender, doesn't qualify, decides to represent herself. The next court date's on March 7th. And when that court date rolls around, obviously there's still no blood test results back. And so the judge suppresses that evidence in the DA's case.
And that is oftentimes your best evidence, depending on how intoxicated the person was. It's really hard to convict someone just based off of their demeanor and what they look like. I mean, it can be done, but having a BAC or a THC in there where it's above 5 nanograms or in the BAC instance above a 0.08, it's great evidence for the prosecutor to have.
Yeah, and you were a prosecutor, I was a prosecutor. If you got that test result, that's really what you're hanging your hat on in most of these cases. So when the judge decides to suppress that, that's a pretty significant sanction for the prosecutor's evidence. And so prosecutor obviously goes, well, we're not going to trial without that evidence. So they appeal to the Supreme Court. And the Supreme Court had an interesting take on it, but basically their opinion was that the discovery rules really don't apply before pretrial. Was that what you saw?
That's what I saw as well. And then discovery rules don't also apply to outside agencies. So sometimes the state can be considered the district attorney's office and law enforcement agencies, but in this instance, Colorado Bureau of Investigation is not a law enforcement agency. It's not considered the state, and the court did not have jurisdiction to impose that deadline on CBI.
So basically, the rule for discovery when it comes to expert reports is that those have to be disclosed as soon as practicable, but no later than 35 days prior to trial. And so the Supreme Court comes back and says, look, you as a trial court have some inherent ability to impose different deadlines as the administration of your docket, but what you can't do is violate the statute, and in this case, it was Rule 16, which governs disclosure of all discovery, and sanction somebody for failing to disclose that since they didn't have the evidence. Now, if they had the blood test results and they're sitting on it or something like that, that might have been different because, if they hadn't disclosed that, then they had the practical ability to do that. Or if they had, some kind of mechanism for getting the blood test results quicker and they didn't do that, then maybe that would have been a different situation. But in this case, the only agency really doing blood test results now in Colorado is the Colorado Bureau of Investigations. So it was really on them to get that evidence out. And because of case backlog, they weren't able to do that within the time that the judge had issued his discovery order. And so the court said that they were going to allow additional time for that. And this was a unanimous decision. There was no dissent, no concurring opinion. All of the justices on the Colorado Supreme Court agreed. It looks to me when reading this case, what the Colorado Supreme Court is saying is that, hey, unless you set your DUI case for trial, there's no way to hold the prosecution's feet to the fire to get your test results back within a reasonable amount of time. Is that what you saw in there as well?
That's what I saw as well, and that's what Rule 16 governs. It governs discovery process for a trial. So if the case is not set for trial, I don't see how Rule 16 could apply.
Yeah. So here's an interesting question. I don't know the answer to this one, but let me get your take on that. It's common for district attorneys to say, hey, defendant, defense attorney, you set your case for trial. We're not going to negotiate anymore, right? You set your case for trial, then we're doing all this work. We're calling in witnesses. We're subpoenaing people. We're blocking off dates on the calendar for trial. So we're not going to make you a plea offer anymore. If this is the case and, you're not getting blood test results out in a reasonable amount of time. If somebody goes and sets their case for trial and the DA says, hey, we're not going to negotiate anymore, even before the parties have their strongest evidence back, is that an issue?
I think it is an issue. I'm not sure what the resolution would be. It's hard to negotiate when you don't know what your BAC or your THC level was or what your client's was. So I don't know an effective way to encourage CBI to get these results out quicker and avoid this kind of litigation.
Backlog hasn't always been the case, but this is certainly something we've seen pretty chronically in the last year. I mean, there is, kind of a standing obligation that prosecutors treat similarly situated defendants the same. But that being said, they're never required to even make an offer. So, that's quite a risk you take, I guess, in setting your case for trial to demand that discovery. I think the Supreme Court's kind of putting people at a catch-22 issue here. To either sit around and have this charge looming over your head until those results come back, or have no chance at negotiating the case.
Yeah, because the stigma is real whenever you're charged with a DUI.